Thank you, Noba, for your kind welcome. First of all, I wanted to acknowledge the traditional landowners of who we gathered on here today, pay our respect to elders past and present. I want to thank Sissy and Anna for the opportunity to speak here today about a very important issue that's affecting my mob in Cape York. And it's about respect and agreement making, or making decisions with traditional owners around carbon projects. I want to speak to everyone today about a very important issue that's affecting my region of Cape York and the need to respect and agreement making on Aboriginal land. The Cape York Land Council is an Indigenous domain. 99% of Cape York is under native title or has already been determined. As many of you will know, the Cape York Land Council has greatly accelerated the determination process and settlement through native title through the Cape York #1 claim. The future of Cape York is bright, and we are determined to support our First Nations people of Cape York to take up their rights and interests through our PBCs and to create effective and productive decision-making processes. Carbon is the second biggest revenue of Cape York after mining. It was estimated at $4 million. Estimated $4 million were made on carbon across Aboriginal land in 2022. Unfortunately, Cape York traditional owners are being sidelined or being unable to participate in the opportunities that carbon may provide. The new carbon farming initiative and methodology means that there will be significant new opportunities for carbon on Cape York. Sorry, this presentation is slow. In particular, from serial restoration and generation co-benefits natural market that is currently being developed by the Australian government. The short, modern history of carbon farming or carbon credits on pastoral leases on Cape York is that some proponents have been proceeded to undertake carbon agreements project on pastoral leases with no agreement from traditional owners. We argue that these projects are not within the legal terms of pastoral leases. Of course, we know that people of Cape York will understand the power and practice of seasonal burning on their country well before the arrival of companies. Sadly, some carbon companies on Cape York on pastoral leases have received de facto support from the Queensland government through the silent question of native title rights on pastoral leases. There's a design flaw in the original CFI Act allowing abatement project to proceed without Aboriginal consent. The issue came to a head in federal court in 2018 through a judicial process in the carbon company, in Country Carbon versus Clean Energy Regulator. The federal government considered whether Country Carbon had the legal right to conduct its project without consent of native title holders. Represented by the PBC of the Kowanyama area, the court decided that the issue was with the regulator and therefore did not consider whether Country Carbon asserted rights undertake Savanna burning, which derived from rights of pastoral leaseholders, was in conflict with native title rights, specifically in the Kowanyama native title area. Although the CFI has seen recent amendments for consent, there is still uncertainty about whether the rights to confer, the rights to conduct different carbon projects within the terms of their leases. We need agreement making with native title holders. We're still awaiting the Queensland Government's response to this. This is a situation that Cape York traditional owners feel deeply unhappy about, and rightfully so. What is the point of having your rights and interests recognised under native title if a third party can negotiate projects with pastoralists that clearly impact the customary and ancestral rights of Cape York traditional owners? Without any regard or consent, or offer a share benefits generated from these carbon projects, the Queensland Government and regulators does the Queensland Government and these regulators subscribe to the theory of carbon nullius? This story is still being written, and a successful future of carbon projects on Cape York for both pastoral leases and Aboriginal land will need much more thought and design. At the heart, we need recognition for the rights and interests of our traditional owners on these pastoral leases, and for there to be best culture, for there to be culture and best practice agreements making with regulators, government proponents, lawyers and traditional owners. The recent purchase of pastoral properties by carbon companies for premium prices has increased the stake, and this future is very unclear. In short, I think these carbon companies that are buying up properties in Cape York, these properties will be lost to us forever. Blackfellas will never see them again. These leases is seen by new owners not as cattle, but as carbon co-benefits. What is the future for Aboriginal land in Cape York? We know that some carbon companies continue to search for legal options to assert that they don't need agreements with us for carbon abatement or other projects. This is not the call of an industry that is interested in a successful long-term partnership with First Nations people of Cape York. I would say, if history is anything to go by, a lot of companies that have asserted their rights in Cape York have not been in there for too long. Many of you would have seen the strong statement made by the Queensland Government last week about a pathway to treaty. We will make our case to the Queensland Government to increase our rights for a fair go for native title holders and with a share in the benefits of carbon and other markets on pastoral leases. Our message to all companies interested in doing business in Cape York is that building a relationship with TOs and agreement making is a fundamental foundation of success in our region. Having a license to operate in Cape York means much more than just legal licenses. Again, our history has shown that companies that build relationship with TOs and take a long-term view are successful. Good agreement making with traditional owners does not have to be complicated. It does not have to be difficult, as it is often portrayed. It requires an understanding and respect for our rights, our interests, and our laws. The principle of prior and informed consent are embedded in the Native Title Act, and I understand the Queensland Government are slowly considering adopting this framework. Free, prior, and informed consent gives both the rights to say yes and no for all agreement making and negotiation. I would refer to any proponents and traditional owners as an excellent guide in carbon projects developing in partnership with Indigenous carbon industry networks. Agreement making becomes all more important where there are complex projects or approvals, as for many projects, and also the creation of co-benefits together with the carbon credits. TRs must understand that both opportunities, but also the risk of liabilities involved with the agreement making. Traditional owners must also understand the proposed project that is fair and there is a fair rate of return. In most cases, the best outcome for agreement making is that traditional owners can negotiate an equity and a stake that gives them a fair rate of return and creates a natural incentive to support ongoing success and the delivery of outcomes for the life of the project. This will benefit everybody. I think before coming here, I had a meeting with the other Queensland rep bodies on Monday, and I think I speak for all the rep bodies in saying that, the rep bodies are of the view that pastoral leases do not include the right to conduct projects without the change in purpose of the lease. The change of purpose of lease is a future act which requires native title consent. Native title consent for the change of purpose should be by Indigenous land use agreement or by an ILUA. The Queensland Government is of the view that these projects are part of land management and are a permissible use. I'm not here to put any more knives in these carbon companies, but I think it's important that there needs to be a proper case study developed on decision making, not just in Cape York, but across the country, where traditional owners, their rights and interests are certainly protected. I'm going to sit now, but I think I'm happy to answer questions after the other panelists. So thank you.